Two celebrities in life-altering crashes when neither was behind the wheel. Yet their cases unfolded in completely different ways. This begs the questions: how can you determine liability when a crash turns deadly? Today, we're breaking down the legal sides of two shocking celebrity crashes. We're going to talk about Paul Walker's fatal ride in a Porsche Carrera GT and Kevin Hart's near-death accident in a classic car he gifted to himself. From the wrongful death lawsuits to hidden liability, here's what really happens when fame meets tragedy on the road, with some legal tips you can take with you if you're ever a passenger in a crashed vehicle. On November 30th, 2013, Paul Walker and his friend Roger Rodas left a charity event in Santa Clarita, California. Rodas was an experienced race car driver, and he was behind the wheel of a Porsche Carrera GT. Less than 1 minute later, they were both dead. The car struck a tree at over 90 miles an hour and burst into flames. Investigators ruled out drugs, alcohol, or even street racing. They simply were driving too fast. Paul Walker's daughter filed a wrongful death lawsuit, but not against the estate of Roger Rodas, against Porsche themselves. She argued that the car lacked basic safety features, such as an electronic stability control, and claimed that their fuel system, which ignited upon impact, was partly to blame for her father's fatal injuries. Roger Rodas' family also sued for the exact same reasons. Ultimately, one family won while the other lost. Porsche settled quietly with Walker's daughter for an undisclosed amount, but without admitting fault. Meanwhile, a judge ruled the crash was not caused by design flaws, and so Roger Rodas' family lost their case. The answer comes down to something that we deal with all the time: contributory negligence, or in simpler terms, who helped cause the crash. Roger Rodas was the driver. He was ultimately negligent in the way he was operating the car by driving too fast. But Paul Walker didn't control the vehicle, and so he had zero evidence of contributory negligence. So how does this liability change when the celebrity victim actually owns the car, even if he wasn't driving it? September 1st, 2019, Kevin Hart is riding in a 1970 Plymouth Barracuda that he bought for himself as a birthday gift. His friend was driving when the car veered off Mulholland Drive in Malibu and crashed, but the car was heavily modified. No airbags, no modern safety features. Under California law, owners can be held liable even if they weren't driving if they knowingly allow others to operate an unsafe vehicle. If Hart paid for or approved those modifications that made that car unsafe, he could be seen as creating or maintaining a defective or dangerous product. Under California Vehicle Code 17150, a vehicle's owner can be vicariously liable for damages caused by anyone who had permission to drive their car. Based on experience, medical bills, lost wages, and maybe even punitive damages, that could all add up to a potentially $10 million lawsuit, depending on how many of the passengers filed claims. Now, let's say his friends are watching this video and $10 million sounds awesome. Could they decide to go ahead and sue him right after liking and subscribing to this channel? The answer is no. The statute of limitations on personal injury claims and negligent entrustment is only 2 years, and that was 6 years ago. In high-speed crashes, liability isn't always about who was driving. It's about who was responsible for the condition in which the car being driven led to the wreck. If you or someone you know has been in a crash like this, the most important thing is to get documentation. Photos, witnesses, vehicle history, and medical records can make or break a case. So if you've been injured in a car wreck through no fault of your own, give us a call at Angel Reyes & Associates for a free consultation.